Hey everyone, welcome back to the channel. In today's video, we've got some huge news that's going to have a direct impact on thousands of people across the UK. It's all about the High Court ruling in a case involving the Department for Work and Pensions, or DWP, and their attempt to slash vital benefits for some of the most vulnerable people in our society. The recent legal battle involving the Department for Work and Pensions, DWP, and its attempt to reduce the vital £416 severe disability premium, SDP, payment has been a major focal point for disability rights advocates, politicians, and the public alike. This case centres around a decision by the DWP to remove the £416 SDP, a financial lifeline that has long been provided to individuals with severe disabilities and their carers. The SDP is particularly crucial for those who cannot work due to their disabilities, as it helps cover essential living costs, including rent, utilities, transport, and sometimes even special medical equipment or services. For many people with disabilities, this payment is not a luxury or an additional benefit, but a necessary support that enables them to meet basic needs and maintain some degree of independence. Without it, many would struggle to survive, adding to the already significant financial burdens that come with living with a disability. The government's decision to cut this support was framed as part of a broader welfare reform aimed at simplifying the benefits system, but this rationale did little to ease the concerns of those who would be most affected. Disability rights groups, activists, and welfare campaigners immediately saw the cuts as not just a bureaucratic adjustment but an outright attack on the disabled community. They argued that the government was attempting to balance the books by cutting funds from the most vulnerable people in society, those who already experience extreme levels of inequality, both socially and economically. As soon as the DWP announced its intentions, opposition to the cuts grew louder, with many calling the proposal discriminatory and a violation of human rights. Legal experts quickly weighed in, pointing out that such cuts would likely violate several key pieces of legislation, including the Equality Act 2010 and the Human Rights Act, which protect individuals from discrimination based on disability. They argued that removing the £416 payment would have a disproportionate impact on disabled people, worsening the already significant disparities they face in terms of access to education, employment, and healthcare. The legal challenge that followed was not just about money, it was a fight for fairness and equality in the social safety net. Disability rights organizations and individuals who would be directly affected by the cuts came together to take the DWP to court, urging the High Court to rule that such a reduction in support was not just unjust, but unlawful. They contended that removing the severe disability premium would breach the fundamental rights of disabled people, particularly under the European Convention on Human Rights, which prohibits discrimination based on disability. The case quickly garnered national attention as it highlighted not only the specific issue of the £416 payment but also broader concerns about the government's approach to welfare and its treatment of disabled individuals. With thousands of people potentially at risk of losing crucial financial support, the case became emblematic of the wider struggle for disability justice in the UK. It raised key questions about how the government views people with disabilities, who often face barriers to full participation in society, from accessing employment to participating in social and cultural activities. The ruling in this case was highly anticipated, and when the High Court delivered its decision, it marked a significant turning point. The court ruled that the DWP's proposed cuts were unlawful, signalling a major victory for those who had been fighting for the retention of the £416 SDP. The ruling was hailed as a win for disabled people, who had been advocating for the government to respect their rights and ensure that the welfare system did not penalise them for their condition. The judgment was not just a legal victory, it was a powerful reminder that the rights of disabled individuals should never be compromised, even in the name of cost-cutting or simplifying government processes. For those who were at the heart of the legal challenge, the ruling was a moment of triumph, a tangible affirmation that their voices had been heard and that the system was beginning to take their concerns seriously. However, while this was a crucial victory, it's important to note that the battle is far from over. The DWP still has the option to appeal the decision, which means that the £416 payment is not guaranteed to remain in place forever. If the DWP decides to appeal, the case could move to the Court of Appeal, where the final decision could potentially be overturned. This introduces a level of uncertainty for those who depend on the £416 support, as the outcome of any future appeal could change the financial landscape for disabled individuals once again. While this remains an ongoing issue, for now, the ruling has provided a sense of security, at least temporarily, for many who rely on the payment. The court's decision also sends a strong message to the government about how it must approach welfare reform moving forward. The High Court's judgment indicates that any changes to the welfare system must be done with due consideration for the most vulnerable groups in society, including those with disabilities. It's a reminder that policies must be crafted in a way that protects individuals' fundamental rights and ensures that support is provided fairly and equally to all. The case has sparked an important conversation about the treatment of disabled people in the UK, particularly in terms of the social safety net. Disability rights activists have long called for a more inclusive welfare system that takes into account the additional costs and barriers faced by disabled individuals. These advocates argue that disability is not a choice, and people who experience it should not be punished by a system that fails to support their basic needs. The £416 SDP, in many ways, represented more than just financial assistance. It was a recognition of the additional challenges that disabled people face and a commitment to providing them with a fair chance to live independently and with dignity. With the ruling in this case, there is hope that the government will reconsider its approach to disability benefits and that future policies will be more attuned to the needs of disabled individuals. However, this victory should not be viewed as the final step in the journey. While the immediate threat to the £416 payment has been averted, the underlying issue remains. The UK welfare system has long been criticised for its treatment of disabled individuals, and many feel it still falls short of ensuring equal support for those who need it most. In the wake of the ruling, disability rights groups are calling for comprehensive reforms to the entire system, urging the government to rethink its approach to benefits and social care. They argue that the system must be more flexible and adaptable to the diverse needs of disabled people, offering not just financial support but also access to essential services and opportunities that can improve their quality of life. The fight for disability justice is far from over, but this ruling provides a glimmer of hope that the government will be held accountable for its actions and that those who are most vulnerable in society will not be left behind. In the years ahead, it's likely that this case will serve as a touchstone for future legal challenges in the welfare system. If the DWP decides to appeal the decision, the outcome could have far-reaching consequences for disability rights and social policy in the UK. Regardless of what happens next, however, the message is clear: the welfare system must be fair, just, and inclusive, and any attempt to cut vital support for disabled individuals will be met with resistance. The ruling has already sparked important discussions about how the government views its most vulnerable citizens, and there's hope that it could lead to lasting change in the way disability benefits are structured and administered. As we wait to see what happens next, it's important to remember that this is more than just a legal case. It's about ensuring that disabled people are treated with dignity and respect and that they have the support they need to live their lives to the fullest. In the end, the outcome of this case may have profound implications for the future of welfare reform in the UK, and for the many people who rely on the benefit system to survive and thrive. It's a reminder that when it comes to social justice, the fight is never truly over, but every victory counts in the ongoing struggle for fairness and equality.